Everybody is familiar with a will and what a will does. It passes your assets when you die. A lot of people think that if they have a will, they have an estate plan. No, they do not have an estate plan. A will is not an estate plan. It is one document that makes up your estate plan. One of the things that I want to focus on are the assets that do not pass under your will. If an asset doesn't pass under your will, then where does it go? When people say, oh, I've got a will, I've got everything covered, that is actually the start of the conversation. Okay, you have a will and it says that your assets go where you want them to go. Let's talk about what are your assets. Oh, you have a life insurance policy. Well, who is the beneficiary on that policy? Who will get the proceeds on your death? Well, if it doesn't say the same people or whomever you want it to go to, then that is going to be an asset that's either directionless or an asset that will go where you don't want it to go. So a life insurance policy is one of the types of assets that generally does not go under your will because it has a beneficiary designation. Think of all the assets that you have. You might have an IRA or a 401k or some sort of retirement plan. Those don't pass under your will, and those could be the largest asset you have other than your house. So where do those assets go? Again, it's going to depend on the beneficiary designation. You need to make sure that's consistent with what your estate plan is. Who will get it is who you want to get it, because do not expect your will to encompass these non-probate assets because your will does not. I'll back up a little bit. Let's say that all of those assets have no beneficiary on them, and let's say that those assets don't in and of themselves direct where they go. A 403B, for example, can say it's going to go to your spouse just by the form of that investment. But let's say there's no such thing that's saying where this asset goes and there's no beneficiary on it. Then it will pay to your estate. And if it pays to your estate, it will go under your will. So you might be saying, okay, Lynn, well, what's wrong with that? What's wrong with that is you do not want to direct assets through your estate, through your will, if that makes those assets open subject to creditors' claims. So a life insurance policy passes to whomever on the beneficiary designation and is not subject to creditors' claims. Well, if you have creditors coming against your estate, why would you make life insurance proceeds available to pay a creditor when, if you had it go by way of a beneficiary, creditors will never get them? Similar analysis with IRA accounts. So as a general rule, we do not want certain assets ever to pay to your estate because that subjects them to creditors' claims unnecessarily. Other assets that won't go under your will include joint account ownership. If you own like a bank account or any asset that can be held as a joint ownership, joint with rights to survivorship, for example, that asset is, again, a non-probate asset. Non-probate means it doesn't go under your will and it will go to the joint owner. So when we do an estate plan, we spend a good amount of time talking with the client about all of their assets. We need to know everything that they own so we can set up the estate plan to accomplish their goals. So having a will is not enough. There needs to be a much more thorough, comprehensive discussion and understanding of your assets.